oral argument once at the Eisenhower Museum. Okay.
Oh, wow.
So we are now live on YouTube. So we'll go ahead and get this matter started. Welcome to the morning docket of the Kansas Court of Appeals. It is April 6th, 2022. And I am Karen Arnoldberger. I'm the Chief Judge of the Kansas Court of Appeals, and I'll be the presiding judge over this particular panel. Also joining me today is the longest serving member of the Kansas Court of Appeals, Judge Henry Green, who hails from Leavenworth. And also joining us today is our long-serving senior judge, Richard Walker, who hails from Newton, I believe. And so we are happy to be here today. We have read your briefs. In some cases, we've read the transcripts. I will be keeping time. You have 15 minutes each side to argue. I'll be asking Mr. Wilson if he wants to reserve any rebuttal time in just a moment. Okay. Do you wish to reserve rebuttal time, Mr. Wilson?
Yes, I'd like to reserve a minute or two if I could.
Okay, we'll put 2 minutes. And
yeah.
And I also have to admit that I'm not very good at keeping time because I get wrapped up in listening to the arguments and I often forget. But so you'll probably both end up getting a little more than 15 minutes, but we do want to make sure we hear your arguments and understand what your position is. So as I indicated, we've read the briefs. We know the facts of the case. You only have 15 minutes, so you don't need to go over those facts. But as we've done things on YouTube and we have more people viewing the proceedings than we've ever had before, we often find it good to set out the facts. And in this case, since they're fresh in my mind, and I don't want to have to go against any of your 15 minutes, if you don't mind, I'm going to summarize the facts as I understand them to be. When you each get your opportunity to speak, you can certainly correct me if you think I've misstated anything, but I think I've got my sights to the record on this. This case was dismissed by the district court under a summary judgment standard. So the case has never gone to trial. The judge found that basically there's no legal basis to proceed in this case. And what's at stake here is roughly $30,000 in insurance proceeds. Mr. Stroud, who is the husband of Kathy Stroud, the plaintiff in this case, was 67 years old when he died. And until 3 months before his death, he had a 20-year term life insurance policy with Ozark National with a $60,000 benefit that he paid $400 a year for 17 years at this point. That was scheduled to increase, as we have all found insurance does. As you get older, your premiums go up, and at 20 years, since it was a 20-year term, his premium was scheduled to go up considerably, I think by 3 or 4 times what it was. So somewhere in the neighborhood of $1,600, $1,800 a year. And that would then continue to increase every year thereafter until he passed. So basically, he's getting less and less value from his policy the older he gets based on what he's paid. And that's typical of all insurance policies. There's nothing unusual about that. So this was going to happen at the 20-year mark or the 21st year mark, and if he turned 70 as well, he would be unable to convert it to a whole term policy. So in 3 years from the date of his death, he would have had some decisions to make about whether to continue the coverage as a whole life coverage. If he converted it to a whole life coverage, he would still have a high premium amount. It'd still be about, can't remember exactly, but let's say $1,500 a year. But it wouldn't continue to increase. He'd be able to lock that amount in, basically. So this was an option set out in Ozark National Policies, and it was something that Ozark was very proud of, and their agent said was a huge benefit to the Ozark policy would be able to have this conversion benefit. Okay, at least according to the agents in their depositions. And typically Ozark would send a reminder a year before the person got to this, kind of drop dead date for conversion. And then their agent would follow up about, do you want to convert this to a whole policy? And due to the low cost of insurance up to that 20-year point, it really wouldn't be in anybody's interest to do that conversion until they reach that sweet spot, let's say. Okay. So in addition, insurance agents everywhere, and including with Ozark, get a commission that is based on when they sell a policy, they get a portion of the premiums the insured pays through the life of the policy. And although another agent can jump in and sell a policy to someone that currently has an agent with Ozark, that's the common courtesy is not to do that, that the agent that has it keeps the policy and continues to service those clients. And also Ozark had a policy that managers could sell life insurance. And if they did, they not only got the agent's premium, but they got kind of an up fee as a manager too, called a manager override, I think. So here in this case, 3 years before Mr. Stroud got to that spot, a manager at Ozark National contacted him. And Mr. Spoon had been the one that sold this policy to Mr. Stroud 17 years earlier. But Manager Gwynn came in and talked to Mr. Stroud, said he wanted to talk to him. This is 3 years before that 20-year mark, wanted to talk to him about converting his policy. And as far as I gather, this was unbeknownst to Mr. Spoon, who was the original agent. So he talks to Mr. and Mrs. Stroud and is aware, at least according to the stipulations that were made for purposes of or uncontroverted facts for purposes of summary judgment. He talks to Mr. and Mrs. Stroud. He's aware that Mr. Stroud is awaiting life-saving surgery, dangerous surgery, that basically places Mr. Stroud on death's door at that point. After that conversation, he sells a new policy to Mr. Stroud for half of the benefit amount, which is $30,000, and 4 times the premium amount. So he's having to pay this $1,500 premium, plus he's getting half the insurance coverage, but he now has a whole life policy. And they cancel out the $60,000 policy. Mr. Spoon testified in his deposition that under no uncertain terms that this was not in Mr. Stroud's best interest, and he would have never done it or suggested it that early in the policy. So Mr. Stroud's life-saving surgery, unfortunately, was not successful, and he passed. And his widow now gets $30,000 instead of the $60,000 they had just 3 months earlier. So after the death, and she gets the $30,000, Mrs. Stroud kind of calls foul and contacts the insurance company, and the insurance company denies her request to get the original $60,000, says that, Mr. Gwynn didn't misrepresent anything. Mr. Stroud had signed all the papers saying he knew what he was doing, and they were not going to make good on that claim. So Mrs. Stroud then sued, and that's the basis of this lawsuit. And Ozark argued that Mrs. Stroud didn't have the ability to bring these claims for negligent misrepresentation and breach of a fiduciary duty, because the insurance company didn't have a fiduciary duty to her, and she's not able to bring a lawsuit on behalf of her husband unless she brings it as the executor of his estate on behalf of the estate. And the district court, that's a very simplistic view of the issues, but the district court agrees and dismisses the lawsuit. And Mrs. Stroud has now appealed, and Mr. Wilson represents Mrs. Stroud. And so with that, I'll let you, I think that's where we are. So Mr. Wilson, if you want to proceed from this point and correct me if I screwed anything up there.
Thank you very much. That was an excellent recitation of the facts, and I appreciate knowing that you've read the briefs and are familiar with the facts in that manner. The only thing I might revise on what you said is that you mentioned that he contacted Mr. Stroud, and actually that first telephone conversation was with Mrs. Stroud. So for whatever that's worth. So
and she apparently said, he said, I want to talk to you about this. And she said, well, at least her allegation is she said, well, if you want to talk to him, you better come now because he's
that's right.
in a life-threatening situation.
Yeah, it's if we need to talk about the life insurance, and it was always a we thing. It was the two of them together in this. And so what I would like to specifically address in the time we have for these arguments are the court's finding that defendant Gwynn did not supply any false information with regard to plaintiff's negligent misrepresentation claim. I'd like to address that. And then also this business about fiduciary relationship, particularly the district court's reliance upon the Spencer case, which we claim is just totally inapplicable. But the court did state that plaintiff has not specified any information that was false. And it seems to me the court is stating that in order to have a negligent misrepresentation case, one must make an untrue statement of fact. And it's plaintiff's position that negligent misrepresentation can be made by making statements, each one of which may be technically correct, but they are made in such an order that when taken together, a false conclusion is being conveyed. So in our case, when defendant Gwynn calls and talks with Mrs. Stroud and says we need to set up a meeting to discuss Mr. Stroud's life insurance, and at that meeting, they get together and Mr. Gwynn stresses a need to discuss converting that policy to a whole life policy because, as he said, the premiums are going to drastically or dramatically increase, and they needed to change that policy before that happened. The Strouds replied, well, you know, Mr. Stroud's going to have this life and death surgery anytime. We're going to Houston anytime. And if we get down there and there's not enough money in our checking account, we're afraid there won't be enough money to pay the premium if they go up while we're down there. And Mr. Gwynn replied, if that happens and a payment was missed, Mr. Stroud might not be able to get replacement life insurance due to his health condition. And when he said that, it is negligently communicating the false information that those premiums on that term policy are going up very soon, and there is a need to convert the policy at that time. That was false information because, as was indicated in the facts, those premiums were not going up for another 3 years. The definition of negligent misrepresentation requires the person furnishing the false information to use reasonable care in communicating the false information. Excuse me. And then in the Steck Schulte versus Jennings case that we cited, the court stated negligent misrepresentation addresses the negligence of knowledge of material fact and the transmittal of already known material fact. And it's this latter part of that statement that we rely on. In other words, defendant Gwynn didn't have to say these premiums are going up soon. By communicating known facts in the way that he did, that leads to the conclusion that those premiums are going up soon, we get to the same place. And it's plaintiff's contention, that's negligent misrepresentation. So we think a jury is entitled to hear that evidence and see if it comes to that conclusion.
Mr. Wilson, I agree. Let's say we assume this was negligent misrepresentation. My big concern, how do we get past the real party interest argument that is being made? That seems like the trial court relied on, and certainly in rendering a summary judgment. And of course, we know Ozark and Gwynn is relying on this argument.
Right.
How you get around that?
Well, number one, the right to sue is only brought up with regard to the fiduciary relationship argument. However, we do cite the Pitt case, which was a similar case where representations were made by the insurance agent to both the insured and his wife. And in that case, the court held that the insured did not have a cause of action. The insured's estate, because he then relied on Patterson to say, well, you need to open an estate, did not suffer the damages. It is the insured who suffered the damages, and the beneficiary is entitled to sue for those. We also rely upon just the definition of real party and interest that
the Pitt case, okay, and I'm aware of that, and I looked at that. That is the Iowa decision.
yes.
Okay, it can be persuasive, but it's not precedent setting that we have to follow. We do have, as you indicated, we have cases here in Kansas that doesn't necessarily agree with what Pitt is saying. As far as talking about a real party in interest, and let me be fair with Pitt. The real party in interest never came up in that particular case. Is that correct?
Those terms did not, but it was argued, did she have the right to sue, I believe. And it was stated that she did, and that a probate estate did not have to be opened.
But we have the real party in interest in our case, this case here in Kansas.
Yes, we do.
It's me. Okay. Go ahead.
Well, I was going to go to the fact that I've seen two definitions for real party and interest. One is that they have the right to be enforced. So who has the right to be enforced in this case? It can't be Mr. Stroud or his estate, because they did not suffer any damages. And in order to have a claim for breach of fiduciary duty, for example, you need duty, breach, causation, and damages. The estate was not the beneficiary of this policy. It did not have damages. So you can have the creation of a fiduciary duty with Mr. Stroud, but the cause of action for the breach of that duty belongs with Mrs. Stroud, because she's the one who suffered the damages. She's the one who has the right to be enforced. Also,
when you talk about, when you talk about fiduciary duty, you have Ozark citing Spencer, okay?
Mhm.
And what Spencer talks about, if you have a first party relationship between an insurance company, there is no breach of fiduciary duty. You almost have to have a third party situation before you have a breach of fiduciary duty. What's your response to that?
My response is, first of all, the fiduciary duty that was created in this case is not with the insurance company. It's between Mr. Gwynn and plaintiff and her husband. The Spencer case spoke in terms of fiduciary duty between the insurance company and the insured. When it refers to a first party, and that's where we get off track here, and I think that's where the district court got off track, and that is that the first party relationship in the Spencer case is where the insured has a claim against the insurance company under the insurance contract. Spencer involved a claim for failing to pay a fire damage amount under the insurance contract. That's not our case here. We're not suing on these insurance contracts. We're suing on the law of fiduciary relationship and the fact that Mr. Gwynn came unsolicited to these people offering advice on an existing policy that misled them into changing the policy at a time when there was absolutely no need to do so. Does that, I mean,
yes, I'm seeing you're distinguishing Spencer. Okay.
I think it's critical because Spencer cannot throw out all the law on fiduciary relationship, and it doesn't purport to do that. Certainly when Mr. Stroud walked into the Mr. Gwynn walked into the Stroud household, that was not an adversarial relationship. He was advising them as to an existing policy. When an insured gets in a dispute with the insurance company for failure to pay a claim under the insurance policy, that definitely is an adversarial relationship. Please, and one of the primary reasons I wanted this oral argument is to dispel this notion that Spencer stands for the proposition that anytime you have a dispute between the insured and the insurance company, fiduciary duty goes out the window, and that just is not what that case stands for, in my opinion.
Well, did Ozark and Gwynn have a fiduciary duty to the beneficiary of the policy, or just to the insured under the policy?
Good question. We take the position he created a fiduciary relationship to both of them. He created a fiduciary relationship with the plaintiff, who relied upon him for advice and whatever, the definition of fiduciary relationship. And he did the same thing with the plaintiff, who was present.
Well, don't you really then have two entirely separate claims? One for the insured, which arguably should have been processed by creating an estate, and second for the beneficiary. And I'm not sure the law favors that position.
Well, what we do is we take the law of fiduciary duty, take all those factors, apply it to this factual situation and the plaintiff, and you have, in our opinion, the fiduciary duty. Naturally, if a fiduciary duty to the plaintiff is breached, she's got a cause of action. We take the position that there was a fiduciary duty to the plaintiff, and if that was breached, it is not his estate that has the cause of action. The estate did not incur any damage. It was not the beneficiary of the policy. Mrs. Stroud was the beneficiary of the policy, and she's the one who suffered the damages.
Mr. Wilson, if I understand this correctly, I mean, you're saying that the estate doesn't have a cause of action because the estate isn't what was harmed. The estate was never going to get this money. This money was going to go directly to the beneficiary. So you made a conscious effort. I mean, you made a conscious decision not to sue on behalf of the estate of Mr. Stroud. For that reason, and also I read somewhere I don't know if it was in the arguments or in the transcripts, also the fact that, let's say, what is in dispute is $30,000. If that ends up going into the estate, then there's going to be money taken out of that for debts and to settle the estate. And it ends up, she doesn't get the benefit that she believes was bargained for. So let's just assume for a minute that the defendant is correct, and that the only cause of action really in this case would have been on behalf of the estate. And I think they even suggested in one of their pleadings that there could be a claim for fraud by, of course I can't find it now, but
silence or something.
Silence, fraud by silence, and perhaps some sort of, and I can't remember if the defendant said this or if the district court did in its journal entry, or perhaps some sort of breach of contract, a good faith in, fair dealing, good faith and fair dealing, or something like that. So if that's correct, I mean, has an estate been opened in this case? And if it has, or if it hasn't, could Ms. Stroud still, is there still time for her to bring a claim?
I don't know. I don't know if Mr. Stroud had a will that had to be.
Okay, so there's been no estate that's been opened. At this
Correct.
Point, as far as you know. Okay.
Correct.
And
Correct.
it's been 2 years since his death. Okay. All right.
Yes.
Thank you.
You said something else in there that I wanted to respond to, but I can't remember what it was. So.
Okay. Okay, well, we've taken you up to your original 13 minutes. If you want to close up real quick, I'll still give you your 2 because we asked you a lot of questions.
The only thing I think I'd probably address is the court never found that a fiduciary duty did not exist between the plaintiff and that a fiduciary duty did not exist between the plaintiff and Mr. Gwynn or her husband and Mr. Gwynn. I never found that. It said if a fiduciary duty exists, then the plaintiff can't sue because she hadn't suffered any damages, which I don't understand. Obviously, to me, the $30,000 she was damaged. And then it said if a fiduciary duty was owed to Mr. Stroud, he would have had to open an estate, but that doesn't really make any difference because Spencer bars him from claiming a fiduciary duty, and we've addressed that. So the court never really applied the law of fiduciary duty to either one, the plaintiff or her husband, and we think that needs to be done in that case. And if it is, a fiduciary duty will be found. A fiduciary duty will be found to have been breached.
Thank you. Mr. Hanna, your 15 minutes. I think you're on mute.
There we go.
Okay.
May it please the court. The defendants asked the court just to affirm the ruling of the district court because the district court correctly ruled on really the 3 key issues in the defendant's motion for summary judgment. And the first, of course, is that the plaintiff is not the real party in interest to bring claims that survived her husband. Second, that the plaintiff cannot show that the defendants made any negligent misrepresentation or that Mr. Stroud relied on any such misrepresentation. And third, that no fiduciary duty exists between an insurer and an insured in the context of a first party insurance contract. So those are the 3
Mr.
points.
Hanna, would you agree, though, that the facts of this case, I mean, this case smells, a legal term we use, that this case leaves a bad taste because we had a deceased who for 17 years had paid premiums on a policy. And 3 months before he dies, for whatever reason, he is contacted by the insurance company that leads him to change that policy clearly to his detriment.
Yeah, and I'd like to address that right from the jump.
Please do.
Yes, because Your Honor, I think you made an excellent summary of the facts. I think there are some additional facts that can also be considered. And one of the things that is, a number of the facts in this case are not in dispute. But one of the facts that is in dispute is the nature and extent to which the Strouds disclosed Mr. Stroud's medical condition to Mr. Gwynn.
I understand you argued that, but I went back through the record and there was an uncontroverted fact for purposes of summary judgment, number 20, I think it was, that said specifically an uncontroverted fact that it was discussed at length. Right. And it makes sense. He's dying. Of course, that's what they're going to be first on their mind.
Well, what was the context of what Mr. Gwynn testified to was because this is a conversion of a policy from a term to a whole. Right. There's no medical background that needs to be examined of the insured, which is typical. And certainly it's a situation where so that wasn't the focus of the conversation, which would normally be the case. Mm-hmm. And so that is why, according to Mr. Gwynn, he had no idea of the nature and extent of the surgery. Second, it's a situation where it was not his recommendation. It was not his recommendation that Mr. Stroud go from a $60,000 death benefit to a $30,000 death benefit. What he testified to is what they were concerned about that premium increasing. And so he said, why don't you go for 30 of the term and 30 of the whole life? He would agree with the other Ozark agent, Mr. Spoon, that it wasn't his recommendation to go from 60,000 of a death benefit to 30. And that's why he made the recommendation of splitting the difference of having a 30,000.
Why would that be in his best interest either? I mean, it seems like that's equally not in Mr. Stroud's best interest at this stage.
Oh, well, it would have been, because if you do that at that point, he still gets the benefits of the whole life but he still has the term. And so because that term policy is, that premium is going to substantially increase in 3 years.
In 3 years.
Right. But he's locked in the insurability in the meantime.
Well, he'll be locked in until he turns 70 or until the end of that. They're
Right,
not going to, he can convert it. That's the big benefit of the Ozark policy.
Right. And the other fact that was brought out in this case is that Mrs. Stroud, the same person who claims that she was misled, had a conversation with Ozark in February of 2018. It was in a recorded telephone conversation. And that telephone conversation was produced in this case. And in that recorded telephone conversation with Mrs. Stroud, Ozark told her exactly the premiums of that policy,
Right.
exactly when they were going to increase and the amount. There's no doubt that she was told that accurate information just a little over a year before this May of 2019 telephone conversation with Mr. Gwynn.
Right. But isn't that kind of a red herring? I mean, the purpose of that phone call was she was questioning, well, gee, you know, why is my premium so much more than my husband's premium when we're getting the same amount of coverage? That was the point of her call. She was just trying to evaluate why there was a difference. And that was explained to her.
Right.
Period. End of story.
Right. That was explained to her, including the same specific facts upon which she now claims she was misled. So that would be the point, is
Right.
if she was told the exact, complete, and accurate information, and we can prove it because that was recorded. And then how often do we get the chance to be able to say that was exactly what she was told? And she was told that in this case.
Okay.
And she admitted, to her credit, she admitted in her deposition that, hey, I had no memory of that call. I had no memory of that call, and didn't know it until we produced it in the discovery process of this case, which frankly further, I think, calls into question the accuracy of how well she would remember the May 19 conversation.
Your position is there's no false representation because they had been told multiple times, had the policy that showed the schedule. They knew exactly what was happening. And the fact that this hit them at a pretty emotional time in their lives doesn't matter.
That's right. And clearly the timing is awful. It ends up with an awful result, but it isn't the fault of Ozark or Mr. Gwynn who did anything wrong in this case. And that is why, and that's why we're here. And that's why this case has been defended by Ozark in the case. And then that gets back to the 3 legal points that we're talking about. And the first and the easiest of which is to address is that as the plaintiff is not the real party in interest in this lawsuit. And I can tell all 3 of you have read our briefs. You can see the legal position. It's really straightforward. The Kansas statute says that an action has to be prosecuted in the name of the real party in interest. And I will say that we did not hide the ball on this defense throughout the defense of this lawsuit. Of the defendants, we raised it as an affirmative defense in the answer. And then we were asked, what's the factual basis for your claim that the plaintiff is the real party in interest? And we answered that in an interrogatory. We then raised it in the pretrial order. My point being is this wasn't some gotcha defense that we raised near the end of the case, but we raised it right from the jump.
What about your statement in the one pleading? I think it was the reply to the motion, maybe the reply to the plaintiff's reply to the motion for summary judgment. I don't know at what stage that you said, well, there may be a couple claims that she could have made, but she didn't. So she's out of court. Can she make those? And you objected to any amendment of the petition at that point.
Right.
Is she out of time to bring those claims now on behalf of the estate?
To be honest, Your Honor, I'm not sure. I do not know, because I didn't know, just like Mr. Wilson didn't know, if an estate had ever been opened. And I'm also not sure of what the statute of limitations would be on those. Or to be honest, the
What it
claim,
matters, right?
or res judicata or collateral estoppel, or those things we addressed in law school.
That you would argue if they did.
Exactly. But when it comes back in this case, the plaintiff is trying to assert tort claims like breach of fiduciary duty and breach of negligent misrepresentation. But those are based on alleged duties owed to her husband, who's the owner of the policy to which she was the beneficiary.
Right.
Because if the defendants owed a duty to anybody and the defendants didn't owe a fiduciary duty for the reasons that we've discussed in the briefs, that duty would only extend to Mr. Stroud, the policy owner. So any claim arising from those breaches can only be made by Mr. Stroud or the administrator of the state. The insurance contracted issue was owed by her late husband, by Mr. Stroud. He's the one that applied for the policy, had the right to convert the policy, and was responsible for paying the premiums. But the plaintiff filed this lawsuit in her individual capacity, not as the executor or personal administrator of the estate. So if any alleged misrepresentations were made, they were made to Mr. Stroud, not to Mrs. Stroud. So she asserts she's the real party in interest because she's the named beneficiary, and she asserts a claim for third party as a third party beneficiary, but that only applies to breach of contract claims. And you can't try and mix and match contract law and tort law to try and cobble together a cause of action in this case. And they never made a claim for a third-party beneficiary in the pretrial order. So that turns us to the next point that I'd like to make of the three, and that is the district court correctly ruled on the plaintiff's claim for negligent misrepresentation. Because it's Hornbook law that everyone studied in law school. To make a claim for negligent misrepresentation, you have to first make a factual statement, and second, that was false. And plaintiff has never been able to identify what Mr. Gwynn said that was actually false. We asked him that in response to the plaintiff in response to interrogatories, and they identified 6 statements. And those 6 statements were in the pretrial order. Then we took Mrs. Stroud's deposition and went through each and every one of those. She admitted that all of those were accurate statements made by Ozark or Mr. Gwynn. In fact, some of those 6 weren't even made by Ozark at all. They were statements that the Gwynns themselves had made. And those are identified in pages 21 and 22 of our brief. Now, the plaintiff claims those are out of context and have to be looked at differently. But even taken in context, they were all accurate statements. When you take that doubled on the fact that in the February 2018 telephone call, Ozark told Mrs. Stroud exactly the situation regarding her husband's policy, the term, the premium amount, when that would change, there's no doubt that there was never any misrepresentation made. Also, Mrs. Stroud, the plaintiff, can't show that Mr. Stroud relied upon any of them. There's no evidence as opposed to what Mr. Stroud would have relied upon. We don't doubt that Mr. and Mrs. Stroud made decisions together. That's fairly typical, I think, for a married couple. But there's no indication that Mr. Stroud would have relied upon any specific statement made by Mr. Gwynn, not to mention that none of the statements he made were false. And that's why he can't make a claim for negligent misrepresentation. So that turns us to the third point, the final point, and that is that the district court correctly ruled upon plaintiff's claim for breach of fiduciary duty. And in doing so, the district court did what it's supposed to do. It relied upon proper precedent from the Supreme Court of Kansas, which holds that no fiduciary duty exists in a first-party insurance relationship, such as the one in this case. The Spencer case, which we've already discussed, and that's from 1980, over 40 years ago. No fiduciary duty exists in the context of a first-party insurance relationship. And this is what we have. So when a party seeks to recover from their own insurer, that's a first-party relationship. And that's different from when an insurer is defending on potentially paying a claim to a third-party claimant on behalf of an insured. A fiduciary duty could exist in that situation, but not in this one. And so Kansas courts have long held that no fiduciary duty exists in first-party insurance relationships, such as the one in this case. And again, if a fiduciary duty did exist, it would go to Mr. Stroud, not Mrs. Stroud. Because an insurance agent, he can't owe a duty to both the policy owner and the beneficiary, because if you think about it, then that would put the agent in a irreconcilable conflict, because then a policyholder would always want to keep in mind, well, how much is my premium going to be, right? And that's going to be a factor in the policyholder's decision. But if you're the beneficiary, well, you don't really care about that. You just want as high a death benefit as possible. Well, if the agent owes a fiduciary relationship to both, then he's in a conflict, right? Or what if the owner of the policy wants to change the beneficiary? Well, if the agent has a fiduciary duty to the beneficiary, that puts them in a conflict between, well, do I do what's in the best interest of the policy owner or the best interest of the beneficiary? So that's why you can't possibly have a fiduciary relationship to the beneficiary, of who Mrs. Stroud is in this case. And the Spencer case is clear that you don't have a fiduciary duty to the policy owner.
That makes a lot of sense, Mr.
Right.
Hannon. That certainly gives some context there. And the bottom line is, in this case, Ozark National fully supports what Mr. Gwynn did here.
Right. Yes, because he did, right, he did nothing wrong. Now, I mean, I will say,
Nothing wrong.
right. Well,
Okay.
what I would say was, I think Mr. Gwynn would also say, in hindsight, he should have called Mr. Spoon. He should have given Mr. Spoon a heads up that, hey, you're starting to cycle off the business. You're starting to cycle off the business.
Mr. Spoon said he wasn't cycling off the business.
Right, but I think the financial implications that shows the amount of business he was doing indicates otherwise. Because the fact is his business is substantially increased through the years. But the reality is, I think Mr. Gwynn would say, you know what, in hindsight, I should have done that. But in the reality,
is it that he should have contacted Mr. Spoon, or that he should have realized what he was doing, what he was getting this man to sign off on, was going to be terribly detrimental to him?
well, Your Honor, I would say this. First, again, he did not recommend that he changed it from a $60,000 death benefit to a 30. He recommended that he had two separate policies. Right. And then at the end of the day, it was Mr. Stroud who made that decision. And then Mr. Stroud, who also had 30 days after he met with Mr. Stroud or Mr. Gwynn to cancel the policy, and chose not to. So that is
ifs and ands were
right. It is an unfortunate decision, but it's certainly nothing that Mr. Gwynn or Ozark did wrong. And again, in conclusion, the district court made the right decision on the three key issues in this case. First, the real party and interest issue. Second, that there was no negligent misrepresentation ever made, and plaintiff has never identified what it was. And third, that there is no fiduciary duty at issue in this case. And for those reasons, the district court's ruling should be affirmed.
Thank you. Mr. Wilson, you have 2 minutes.
Yes, ma'am. First of all, this false statement business, this statement of, well, if it happens that the premiums go up while you're in Houston, you're going to lose your insurance, or whatever that statement was. You know, if you take that statement and just look at it, it's a true statement. If the premiums go up when they're in Houston and you miss a payment, you could lose your life insurance. That's a true statement, but you put it together with that conversation and you've got a negligent misrepresentation. Then with regard to a lot of these other things brought in, this telephone call and all that, we must remember this is a motion for summary judgment appeal. And a lot of these facts that are being brought in, both in the briefs and in oral argument, weren't before the court as far as stipulations were concerned. And it's those stipulations we've got to look at. There was a statement that no evidence of reliance. There's a stipulation of reliance in the uncontroverted facts. We cited a Marshall case, a Kansas case, that I just want to remind the court of, that did recognize a fiduciary relationship between an insurance agent. And remember, it's the fiduciary relationship between the insurance agent and the insured and plaintiff that we're talking about here, not the insurance company. But that case recognized, where there was just the two of them, a fiduciary relationship. As far as claims that could have been made or legal theories that could have been, we could have brought this on, maybe fraud by silence. Actually, we're giving Mr. Gwynn a break. We're saying, okay, maybe you didn't intentionally defraud us here by silence, but you sure negligently miscommunicated the facts. Again, real party and interest, no damages, no cause of action. The only person who was damaged here was Mrs. Stroud. And we do rely upon the liability of the insurance company being based on vicarious liability And as Your Honor said, they approved everything, ratified everything that Mr. Gwynn did. So thank you very much for your attention this morning.
Any other questions from the panel for Mr. Wilson? Okay, thank you very much. We'll take the matter under advisement and get you a decision as quickly as possible. We appreciate your arguments today. We recognize this is an important case, and you've both done a superb job of presenting your positions. Thank you.
Thank you.
Thanks, all.